Do you have to refinance the mortgage when you inherit the property? It depends. This is usually going to be controlled by a federal law that came about in the 1980s called the Garn-St Germain Act, which in large part determines if property would need to be financed or not during a transfer, whether it was a transfer during the life of the owner of the property or a transfer in this case upon their death. So the whole reason for the 1980s law, the Garn-St Germain Act, was because several states had enacted laws where lenders were no longer permitted to invoke due on sale clauses when the property was transferred from one owner to another. A due on sale clause is a clause or provision in the mortgage documents which allow a lender to call the whole mortgage due, the balance of whatever is owed on the mortgage due, if the mortgage is transferred. So this could be like upon a sale or, upon an inheritance, or you're giving it to a family member. But if it transfers from one owner to another, it gives the lender the ability to say, hey, new owner, now the whole, whatever the balance was for the mortgage for the previous owner, that needs to be paid. And because it was not necessarily fair to make it so that due on sale clauses can never be invoked, that's why, in large part, why the Garn-St Germain Act came about. And one of the things that it does cover is inheritance of property by relatives. So in the instance when a relative is inheriting the property of it could be a parent, it could be a grandparent, but essentially you're inheriting property to someone who you're related to, then you're not forced to refinance. You are actually permitted to assume whatever mortgage they had, or whatever mortgage your relative had on the property. This could come about because they left you the property through a trust. It could also be because it was devised to in a will, or maybe they passed away without a will. Maybe you're their child and you inherit the property that way. Now, the only issue that can sometimes arise is just because the Garn-St Germain Act says that you have the ability to assume the mortgage, meaning you can keep the same mortgage that's already on the property and just make payments on it as the new owner. We're talking about in this scenario if you're a relative now. Just because it says you can do that does not mean the mortgage company is going to talk to you, because legally their client was your deceased relative, right? So you might try to make arrangements and find out that you hit a dead end. So this is often why probates are opened, in order to give a person the power as the personal representative or the executor to be able to actually speak to the lender, the mortgage company, in order to sort this out. Oftentimes it does require assistance from an attorney too, but the way it works with a personal representative or an executor, they basically stand in the shoes of the deceased person. So once you're actually appointed by a court as the personal representative of the estate, you can then talk to financial institutions, mortgage lenders. You can talk to places who had accounts for the decedent. This is often necessary in this instance because it could be very difficult finding a way around having the mortgage company understand what's going on in the scenario. Now, once they do understand, it's often very easy to transfer whatever they need to transfer, get the paperwork done, and then it shouldn't be a problem moving on in the future. But that's something to be aware of or to consider, because if a mortgage is in place, just because you're able to assume the mortgage and you don't have to refinance it doesn't mean that you're automatically going to be able to just call up the bank and say, hey, I'm so-and-so's child and I just got their house. Now I want to take over the mortgage. It may require the extra step of actually needing to do a probate and become the personal representative so that you can, or the executor, so that you can communicate with the lender. All right, so I hope this answers the question. If you have any other questions about estate planning, asset protection, probates, Medicaid, and you're in the Florida area, don't hesitate to reach out to our office. We are in Clearwater. We're at Cause Law Office, the non-stuffy attorneys, and the link is in my bio.